Welcome to the program. My name is Martin Shenkman, and I'm joined by Chriseanna Mitchell and Alan Gassman, and we are going to talk about the Corporate Transparency Act, because what could be more exciting? Thanksgiving's coming. Everybody needs something to talk about at the holiday dinner. And to make it even more exciting, we're going to talk about trusts and the CTA. Very complex issues, lots of problems, and a lot of things to talk about. We're doing, and Alan and I have done, I don't even know how many CTA programs we've done, Alan, but this stuff is coming to a head. There's just not a lot of time before the end of the year, and we just hope it helps colleagues to keep CTA front and center and trying to help disseminate some information and some of the things that we've been thinking about. Before we get started, I'm going to make a quick comment on behalf of Interactive Legal, which is one of our sponsors. ILS is a creator of a document generation software program that really offers an incredible array of forms and provisions. And if you have not adopted document generation, it's something that I highly encourage you to do. I think it makes practice more fulfilling, safer, and far more efficient. And there's the contact data for ILS there. And our other sponsor is Peak Trust Company. Andre couldn't make it, but Jonathan Brandt was going to make a comment on behalf of Peak. Jonathan?
Sure, thanks, Marty. Well, welcome everyone, and thank you for attending today's webinar. My name is Jonathan Brandt, and I am a trust officer with Peak Trust Company, and we are certainly honored to be able to sponsor today's presentation. Peak Trust Company offers trust administration for sophisticated estate planners, offering a full range of trustee services. We serve families and their trusted advisors, and we offer flexible and customized administrative services for all types of trust. If you have any questions, please reach out to me or any member of the Peak team, and enjoy the webinar, and I'll hand it off to Marty and Alan.
Peak is my trustee, one of my family trusts. And if you have not done a lot of work with the various administrative trust companies, as we get closer to the end of 2025 and clients are clamoring to get work done, start creating those relationships and the processes now. Thank you, Jonathan. So we're gonna get started, and before we get started with some of the details, Chriseanna, did you want to make a couple of sort of introductory comments on just the CTA, just to get everyone's sort of perspective focused on where we are?
Yeah, sure. So
and scare them again with reminding them real quick of the penalties. I know they all know, but it's worth scaring them again.
Yeah, so $591 as of now per day that the law goes violated, as well as up to $10,000 in civil fines or 2 years in jail. If they're not playing around, I think it's crucial to go ahead and get this filing in before you run into any of those deadlines. So for businesses that were created before this year, they have until the end of this year, so December 31st of this year, to get their reports in.
And for those not paying attention to the calendar, that's less than 2 months away. It's not a lot of time. Any thoughts? What have you heard about people actually paying attention to this or complying with it?
So for me personally, a lot of people have been waiting it out, and if they have more simple trusts or filings that they're going to have to do, it seems like they're waiting until December before they start filing, just to see if it goes away with all of the pending legislation and everything. But so far, it looks like full steam ahead.
We've talked about it before, Alan, so I'm going to just say it. Alan and I both agree that's kind of not a prudent course of action, kind of a mistake, because what's the cost of filing versus if you don't file and you miss the deadline and FinCEN comes after you, penalties are awful. The word I heard from somebody, and I don't know how accurate it is that, because I didn't see it from the source, FinCEN recently estimated that 4 million filings have been made. But originally, the estimates I heard were there were 32 million reporting companies. So consider we're less than 2 months away, and this thing has been on the books for a while, and they opened up their portal. I think, wasn't it January of 2024 they opened the portal, Alan?
I think so.
Yeah, so, you know, very few people have dealt with this. And I think even if people try to deal with it, at some point, their website just is going to get overwhelmed. There's just way too many millions, tens of millions of reporting companies. And if there's 3-4 people as beneficial owners for each reporting company, that's 100 million filings. It's kind of crazy. So anyhow, that's the general stuff which you all know. One of the problems to give some thought to, and we're going to try to pivot now to more focus on trust. When you have a trust, and we're going to get into this in a little more detail, and you have various people named in a trust that are beneficial owners, they're going to have to report. So if a trust owns an interest in a reporting company, trusts themselves don't report, but people listed in a trust, whether it's a trustee, a trust protector, or others, and we'll talk about that, may have to report. We have clients, everyone has clients, we collectively, that created trusts in 2012 before the exemption was going to go down. We have trusts that we've all seen, old and cold trusts that have been around for decades and decades. And these trusts, you know, do the trustees, the trust protectors, the people with loan powers, do they have any idea they've even been named in these documents? I believe that in the majority of cases, most practitioners have not had these ancillary people other than the trustee even sign the trust documents. And they may not even know they're appointed, but yet they may be deemed beneficial owners. What's going to happen when somebody's ex-brother-in-law is called to give confidential BOI information to a reporting company in the waning days of 2024? I think it's not only that they're not going to be cooperative, I think it's going to be a major problem. And I don't think most clients have grappled with the idea in the context of trusts owning interests in reporting entities. And let me clarify, that's not a correct statement. You have to file if you own 25% or more, or have substantial, air quotes because it's a defined term, substantial control. So there could be a lot of people named in trusts that own small interests, but because of the structure, the terms of the agreement, they have substantial control. Clients haven't grappled with, what do you do if you have to change these people because the people named are upset, won't talk to you, don't want to file, won't assist, won't cooperate? Alan, any thoughts on that?
Well, the penalty is for failure to comply, but you just have to make reasonable efforts. So if your ex-brother-in-law won't cooperate, you report everything you can, and I guess write a letter to the Department of Treasury saying this particular person won't cooperate. We tried our best.
So you got a rat on your ex-brother-in-law.
Rat on your, which most of us really want to do anyway.
But what's going to end up happening is, apart from what they do or don't do to deal with it, these folks are going to have to come back to us as attorneys, estate planners, and they're going to have to revise the appointments in those trusts. And, you know, it's nice when you look at a trust document and there's a simple mechanism to remove and replace a person with a loan power. Sometimes, Alan, when you look at an old trust document that we did ourselves, and certainly that was done by someone else, and certainly the older it is, the less robust trusts happen, you know, typically to be, it's not always easy to find a way to do it. And if you can't, you may end up having to decant the trust in order to change these provisions. And one of the things that I've also grappled with is, if you have a trust that's more than a dozen years old, for example, and you have to change three different people that have been appointed because they're not going to cooperate, or you don't want to deal with them for the Corporate Transparency Act. If you have a trust that old, maybe it doesn't pay to try to figure out how to change all these appointments. Maybe better just to decant it and upgrade, if you will, the administrative provisions of the trust, because any of us that look at a trust, even that we did ourselves a decade ago, we can always find things to improve. Drafting styles change, planning ideas change. So to go and decant lots of the trusts that are out there that have interests, either ownership or a substantial control over reporting entities, it's a major project. And I don't think most clients, if any, really seem to get that. Chriseanna, what has to be reported? I know people know this, but let's just remind them real quick so they'll have that in mind as we go through some of the rest of the program.
Yeah, sure. So your full legal name, no nicknames, no initials, none of that. They want your full legal government name, your birthday, home address, and it can't be a PO box. It can't be your lawyer or CPA's address either. It has to be your residential address. And then a copy of some type of identification. The most common ones are probably going to be like your passport or driver's license. And as you mentioned, part of the reason people might not cooperate with this is just because this is pretty sensitive data that they might not feel comfortable sharing with the company or sharing with the trust, or they just feel like being difficult, which we'll get into later, but that's part of the reason why it might be a better course of action to get a FinCEN identification number, just so then you don't have to share that information with the company.
And do one of you want to comment about that's one of the two reasons. The other reason is then the reporting company doesn't have to deal with amendments.
Yes, because then if anything changes, like your birthday is not going to change, but if you get married or change your last name or you move or anything like that, all of this has to be updated, which could be a lot for a company to keep up with, especially if there's more than one beneficial owner. So by giving them the FinCEN ID number instead, then that's kind of off of their hands, and you're just making the updates as you go with FinCEN directly, and all they're responsible for is that number.
It surprises me. I have a client that has dozens of entities, and I was very thrilled to hear her corporate attorney wanted to handle all the FinCEN filings, because I'm not looking for this work. I don't know how you feel about it, Alan, but I'm happy to help somebody if I have to, but it's not something that I'm actively seeking to do. And the corporate attorney was not using FinCEN identifier numbers for anything, was having all these dozens, and there are dozens of them, reporting companies have all the beneficial ownership information submitted from the various people and filing it. And I said, like, no, you got to stop. This is a disaster. And the client got a FinCEN identifier, and some of the other key people did. And at least going forward, they're going to use FinCEN identifiers for the remaining entities that haven't filed, but whether or not they go back and fix the others, I don't know. I was surprised that a very bright, capable corporate attorney didn't think of that. And the problem is exactly as Chriseanna said, is that every time information on the beneficial owner changes, the reporting companies will now have to do a filing, whereas you avoid it with the FinCEN identifier. And almost all of the entities this client has are owned by one of three different irrevocable trusts. So now we have the issues of all those people also having to file, and that was kind of off radar as well. Another thing that I saw, Alan, I don't know if you saw the FinCEN, the CTA program I did on a conference we both spoke at maybe a week or so ago. But what I heard is that one of the reporting companies, and this may be common, I don't know what all of them are doing, they weren't using FinCEN identifiers either. So what they were doing is, if, let's say, Chriseanna is a BOI for a particular batch of 20 different reporting companies, when she would give them an address change, and they'll prompt her to do that, which is one of the benefits of using an outside service, they're in their system, they will file all 20 updates to 20 different reporting companies. I didn't want to ask because we were on a conference, but I was guessing that this filing service company is going to charge, even if it's a modest amount, for each of those filings. So I wonder if that has something to do with the approach of not using FinCEN identifiers. But think about it with the trust. If you have, and we'll go through some of this later, it'll come up again, but if you have a trustee, an investment advisor or investment trustee, and you may have a committee of them, so it could be multiple people, someone with a loan power, someone with the power to add beneficiaries like in a hybrid DAPT, trust protector, if I missed that one, You could easily have a half a dozen people in a trust, and if the trust owns interests, either more than the 25% or the substantial control in a dozen different entities, you have 6 people for each of those dozen entities. It's like tribbles. Alan, do you remember tribbles?
Yes. The
Tell
trouble
everyone how many tribbles there are, because I think CTA filings are very similar.
there's a spaceship full of them. There's a lot.
Yes, and if you don't know what we're talking about, you have to go back and watch your Star Trek reruns.
Trouble with tribbles.
Trouble. Yes, that's exactly the name of the episode.
Yeah.
That's pretty scary that we remember the name of a Star Trek episode from 30 years ago. Chriseanna, you better stop hanging out with us. Another quick point. One of the things that I've started to do going forward, because as we've started to realize the massive implications of the daunting reporting for trust owning interest or having substantial control, we've started to put in the signature blocks on trust documents a FinCEN identifier number in a blank line, FinCEN identifier, blank line. So if a trust protector, which I believe in almost every case is going to be deemed to have substantial control if the trust either has the ownership or substantial control. So they're going to be a BOI. I want to get the FinCEN identifiers up front, because then we don't have to go asking people for it and hunting it down later. So to me, that's just a very practical way to make this easier going forward. It doesn't help us with all the existing stuff, but at least we're not adding to the tribbles as we go forward. Alan, one of the things that we should talk about are BDOTs, BDITs, and what that may mean, and this technique that I know we've both worked with, where you have a special member voting interest held by a separate trust, because that's now adding to the number of people that have to report. Do you want to explain that real quickly, just so it's on people's radar?
Well, sure. For estate tax planning purposes and sometimes for practical purposes, when you capitalize a limited partnership or a limited liability company, you may have voting, non-voting. You may have what we call special voting. So you might have like 0.1% of an LLC owned by the trustee of a grandchild trust, and that trustee
Any
has
non-grantor trust.
What's that?
A non-grantor trust, typically.
Right. That's right. They may hold the power to direct if and when there will be distributions from the LLC, or they may hold the power to manage the LLC assets. Those can all be considered powers to control the LLC. So that little trust, the trustee of that trust, maybe the trust protectors of that trust, maybe the grantor who has the power to replace trust assets, or the beneficiary who could replace trust assets, are all control people for purposes of Corporate Transparency Act. So that's a lot of names, addresses, phone numbers. I mean, a lot of names, addresses, dates of birth, and places of residence, isn't it?
And now when you suggest this type of planning to deflect a challenge under the Powell or Moore cases, what Alan just described, and it's a common technique, you have to mention to the clients that you have more CTA filings. They just keep multiplying. In a BDIT or BDOT, where you have the 5-5 power as the beneficiary, you want to explain that, or you want me to talk about it?
You can do that.
So mom sets up a trust for child and puts $5,000 in it. Child has a crummy withdrawal right to withdraw 5% or $5,000, and that way the entire trust becomes grantor as to the child. So now the child can use that trust created by a third party, so it's not a self-settled trust, arguably, and do a note sale transaction. You may have a guarantee from another family trust or family entities to support the note sale because the assets in the trust are limited. But if you can withdraw all the assets from a trust, you're now a control person for purposes of being a BOI. You now have substantial control. You can withdraw all the assets. So under the FAQs, you're now designated as somebody that has to report. So even a beneficiary that may not be the sole principal or income beneficiary, and we'll talk about some of those criteria in a minute, may still be caught up in the BDOT rules and have to file that way. So the point of the beat it and the Powell technique that Alan described is just to suggest that almost, it seems like almost everything we do as estate planners with trusts, if those trusts have either the sufficient ownership interest or substantial control over a reporting company, and lots of our trusts have more than one entity that they have, one or both of those, you just keep multiplying the number of people that have to file. And I don't think, Alan, any of this is going to be anticipated, expected by clients.
No,
So,
no, or by many practitioners, but hopefully everybody makes a reasonable effort here.
well, yeah, and it would have been nice had they had a, some safe harbors for reasonable efforts, but they didn't really provide anything like that. And I guess the bottom line is FinCEN wants everybody to report because they want to get everyone in the database so they can catch the bad guys. And they're really not making exceptions where it would be reasonable or helpful to have them. So one of the two of the major sources for information, especially more detailed information from FinCEN, is one is the Small Business Compliance Guide, and the second is the FAQs, the frequently asked questions that they update periodically. And there have been a number of comments in the Small Business Guide and a number of FAQs and recent ones issued on specifically trusts. So here's page 19 of the Small Business Compliance Guide. A trustee of a trust or similar arrangement, I'm not sure what that means, can exercise substantial control over a reporting company. And if you do, then you're a BOI and have to report, but it's not limited to a trustee. And they go on to say, a trustee or other individual with authority to dispose of trust assets. Alan or Chriseanna, who could dispose of trust assets?
Chriseanna, I'll give you that one.
Yeah, I was going to say, if it's revocable, the grantor could definitely do that.
Yeah. My impression, but I don't think I'm comfortable with it. I haven't honestly dealt with it in much detail, but you raise an interesting question, Chriseanna, about revocable trusts. I would like to think, gee golly, if I'm a grantor of a revocable trust that owns an interest in a reporting company, I just report because I can revoke the trust and do everything. I don't think that's a fully sufficient analysis, though, because if somebody else is named a trust protector and they have certain powers, if somebody else has the, a loan power, or if there's a mechanism where I name my attorney Alan, so I can't get snookered from elder financial abuse, so I can't do certain things without Alan's permission. Alan could be now a deemed beneficial owner. I don't think it's necessarily just, oh, it's the grantor when it's a revocable trust. Any thought on that?
I think you're absolutely right. It's it's a confusing situation, but when in doubt, everyone reports.
The CTA is confusing, Alan?
Just a bit.
Jeez, what a concept. The sole permissible recipient of trust income in principle. Let me say that again. A beneficiary who's the sole permissible recipient of trust income in principle. Alan, do you ever really write a trust? What kind of trust would someone be the sole recipient? I mean, that's kind of
right. The people who wrote this don't seem very well versed in trusts. They don't seem really comfortable. So they wanted to be darn sure that this would apply. So this would be the only beneficiary of a revocable trust, which is almost never heard of, because typically a revocable trust says, this is for my family, me and my family. I'll veto distributions to anyone other than me, but if you want to make distributions to my children and my spouse and my great-grandchildren and my church, do it. So then are all those people beneficial owners? If you want to make sure they're not, maybe this is our instructions to say, this revocable trust will be held for me and only me until I decide otherwise, so that me and only me are the only beneficial owners of XYZ LLC.
I think the same concept, Alan, apply to an irrevocable trust as well. And I think it's almost backwards from what they intended, because the general sort of lens that FinCEN has looked at is make everyone possible report, because we just want to have everyone in the database so we can catch the bad people. But here, by saying a beneficiary has to report if they're only if they're the sole permissible, if you have a pot trust, and almost like you said, almost all the trusts we do are pot trusts that cover, in a typical situation, spouse and descendants, but it could be nieces, nephews, charities, etc. It's very rare to see a sole permissible recipient of trust income or beneficiary. One exception to that is the beat it that we talked about earlier, where one person has that withdrawal right. I would think that might taint them, because they could pull out all the income and corpus, so long as it's within the 5 and 5 power. But then that changes when the value of trust assets go up. So if they do a note sale to the beat it and the value of the assets increase, so the 5 and 5 power doesn't give them enough right to pull everything out, now we have to file an amendment because they no longer are a beneficial owner.
Let's
go on.
That's a good question. That's a really good one. I hadn't thought of that.
How about someone who has the right to demand a distribution or withdrawal of substantially all the trust assets? The only example I can think of is the beat it in that context. How about a grantor or settler has the right to revoke or withdraw trust assets? I think that's what Chriseanna talked about earlier with a revocable trust. We're going to talk about inheritors in a few minutes. When a beneficial owner dies, resulting in changes to the reporting company beneficial owners, you have to report those changes within 30 days of when the deceased beneficial owner's estate is settled. Alan, when is an estate settled?
Well, for Jimi Hendrix, it's taking a little bit of time. I think an estate is settled when the court issues an order that the estate is done.
And how often do people not go for that?
People forget about the estate, or how do you know when they're even? Sometimes it takes 25 years to figure out that there was an estate because somebody finds an asset that no one thought of. So just report it. Report it, report it, report it, report it. Before the estate is settled.
The purpose of all these prior comments was to demonstrate that Alan is correct, that this is very confusing, and the guidance given by FinCEN is really difficult, not in general only, but especially difficult when you try to apply it to trusts. It's almost, and I don't mean to be insulting to FinCEN, I think, you know, the small business guide, I mean, they really have tried hard to make this stuff understandable, but the trust stuff is very inartfully worded and results in real lack of clarity of what's covered and what's not. And Alan's already given away what the bottom line is for probably every webinar we've done is when in doubt, Alan. Oh, like Chriseanna. Chriseanna, when in doubt,
File.
file.
I know it doesn't rhyme, but it's still meaningful.
Yeah, but we still need to grapple with this because clients are going to want to understand it, and we need to think through what the guidance is because we want to make sure we're not missing people that may be pulled into this that aren't obvious.
Yep.
So let's go through some of the FAQs that talk about trusts, and these will further reinforce Alan's comment about the difficulty of applying the FinCEN guidance to trusts. Trust arrangements vary. That's a profound statement. Particular facts and circumstances determine whether specific trustees, beneficiaries, grantors, settlers, and other individuals with roles in a particular trust are beneficial owners. How broad can you get? That's pretty broad.
Want to cover their bases.
So, but it's also very vague, and it's not really addressing modern trust drafting. So if somebody has a loan power to loan the principal of the trust, maybe without adequate consideration, so it characterizes the trust as a grantor trust to the settlor, I think they're pulled in under that as well. If someone can add a beneficiary, I think they're probably pulled in under that. If someone can add a charity, I think they're pulled in. Alan, some others that you can think of?
Oh, I just want to say this phrase under number 2, owns or controls at least 25% of a reporting company's ownership interests. I understand the ownership part. So that means if I have 25% of the voting rights, that I am considered to be a control person when I'm outvoted by everyone else?
Yes.
This one may just be wrong on its face. I guess I would have to report anyone with 25% voting interest, but that's not in the statute.
Go on, I'm sorry.
No, go ahead.
No, I think it's even beyond that, Alan, because this could be interpreted, at least the way I see it, and the other things that we've read, that if you have someone that's an investment advisor or investment trustee of a trust that owns a small interest, are they not substantial control? How many people do you need? Let's say the trust only owns 10%, but they can vote it with 10 other people. Are they substantial control? What if the what if the operating agreement for an LLC or a partnership agreement for a partnership, 10% of which is owned by the trust, requires unanimous consent for something? So now that 10% has control, doesn't it? Substantial control.
What if I gave a durable power of attorney to my wife and she often exercises it? Does that mean that my control is her control?
They have an FAQ on powers of attorney. The way I read it, it says an agent under a power of attorney does not have to file as a beneficial owner. So Marcia would be off the hook from filing. But that then doesn't make any sense to me because leaving Marcia aside, you have an elderly client that's incapacitated and their child is given a power of attorney and they have a power of attorney to vote the interest in all the different entities the incapacitated, incompetent principal owns. How could they not be required to vote? They're the only one with any control. So it's like you said, it's almost as if there was a gap in the understanding of how not just trust but estate planning broadly is covered by the CTA. I think what they did on an agent doesn't make any sense if they're really looking to get on information on any control person. And when you have to consider the facts and circumstances, that's like just wide open. Let's go on with some of the other items from the FAQ. If a trustee of a trust, they could be a beneficial owner. Beneficiaries could be, grantors and settlers could be. We talked about, and it's just repeating again, the sole permissible recipient, which in that case, it's very narrow because that doesn't come up. Withdrawal of all trust assets. Alan said earlier, someone with a swap power could do it, but there could be others. Somebody with the power to revoke the trust. I think in that context, think not just of a revocable trust, but think of the mechanism that is not uncommon of giving someone like the attorney, for example, a non-adverse party, the power to have to approve certain actions. Like, what about, Alan, if you have a power of attorney, a general power of attorney over a trust, but in order to avoid the risk of you doing something inappropriate or undesired by the settlor, I, as the attorney, have to approve it. Doesn't that now make me a person that would have to report as the attorney with that one power?
Yeah, you're right. Somebody with a veto power over a power of appointment. That's pretty amazing.
So very common in a lot of the irrevocable trusts we do. Child sets up a trust, they give an elderly parent or aunt or uncle a general power of appointment for basis planning, basis step-up planning, so it's included in their estate. But oh gee, what if, elderly mom is, persuaded by a bad actor to do something inappropriate, so I'm going to give Alan, as the attorney for the family, the right that he has to approve elderly mom's exercise of the power. Now, I think you have to file. I think it gets lots of layers of ripple effects that go into planning that is not uncommon, that we all see, that on first blush wouldn't be covered by this, but very well maybe. Thoughts?
I think you're right. You have to be very careful. Marty, maybe we should develop a 25-item checklist of all the different situations we can think of where somebody involved with a trust would have to register, so that people who
I
read
think that would be helpful. Chriseanna, can you? I know this is silly, but
he was just starting to work on it.
read the yellow highlight on the last bullet point.
This may not be an exhaustive list of the conditions under which an individual owns or controls ownership interests in a reporting company to a trust.
We've just covered an awful lot of situations that go way beyond what I would think common expectations would anticipate would be covered. And just in case, it's not exhaustive. And again, that's consistent with what the CTA is trying to do. But in the context of trust, it's very, very worrisome. Chriseanna, how about you take the next couple of slides? And I know we've talked a little about FinCEN identifiers, but I see so many misunderstandings and misconceptions, especially in the context of trust. Why don't you chat about those for a minute? And if I don't change the slides at the right time, just yell at me.
Okay, sounds good. So as mentioned before, this is an alternative method of getting the information that the reporting companies need to them without necessarily giving them your birthday, name, address, and your copy of your driver's license and all of that. So the beneficial owner gets the identification number from FinCEN by uploading all of that information to FinCEN's website. They get this number, and that number is unique to them, and then they could use that in place of their name, birthday. Well, they still would need to get their name, but in place of their birthday, address, and copy of their driver's license to the company. And it seems pretty easy. I think, didn't you get one, Marty? I think it takes like 5 minutes or so to get one. It's
Took me 15. The biggest thing is just make sure you have a PDF of your driver's license or whichever ID you're using before you start the process so you can upload it. I don't think I think it was maybe 15 minutes.
Yeah, it's really
not a big deal.
And considering how much easier it makes life for not only the beneficial owner to not have to feel uncomfortable giving their personal information up to, especially if they're not super involved with the business, potentially strangers, but also it's easier for the company because then, like I mentioned before, every time something changes, like if you move or you get married or you get divorced, whatever, like anything that happens, the company's not responsible for following after you and making sure that information is up to date. You could just go and update it yourself with FinCEN, and all they have is the number, so they don't even necessarily know that something has changed.
And I think, like I said, I've been adding a FinCEN identifier block to the signature, a line item, a blank to the signature blocks on trusts for a while now, because it's going to be on us as practitioners to help clients get this information or get this dealt with. If you ask for a FinCEN identifier and you have a counterpart to the trust signed by persons with a loan power or a trust protector, they know that they've accepted this. They know they have the responsibility to get it, and you get it up front rather than dealing with, what do you mean I have to do that? Not a good end result to leave it unsaid.
Okay, so as mentioned before, you would just give the company that information instead of giving them your birthday and residential address and the copy of your ID. And then the responsibility burden shifts to you as the beneficial owner to keep all of that information up to date with FinCEN so that the reporting company doesn't have to do it on your behalf. I think it's just easier all the way around for everyone involved, especially since it's so quick to do. Like, you might as well get that number, and then you don't have to worry about any of the privacy concerns. You don't have to worry about like someone hacking into the reporting company's database where your information's being stored or any of that, because if someone hacked into it, all they're getting is a number.
And I think for practitioners, many of us don't, but probably most of us are named in various trust documents on entities. if you know that as a practitioner, you're in a bunch of different fiduciary or fiduciary-like positions, get the identifier number now. Just be done with it so you have it if it comes up that a client needs it. Why wait to the crush that's going to be inevitable at the end of the year? And can you imagine, Alan, that the client can't get their filing done because the FinCEN website's down and you're the only number they don't have? I mean, no advisor wants to be in that position.
Yeah, you have to make sure you keep your cell phone on for New Year's Eve when they call you with that last minute advice at 11:50.
I was gonna say, I think that's a great point about the practicality of doing this at the last minute, because a lot of other people are probably going to be doing the same thing. And what, it's like an eighth of them, you said 4 million, so like an eighth of them have filed, which means everyone else is going to be filing within this last month or so. And it's just going to be so
Nuts. It's nuts.
for their little system, it's going to be overwhelmed, and it's probably going to crash multiple times if you're waiting.
I can't imagine how their website's not going to crash.
It's going to, for sure. Like New Year's Eve, it's going to be a mess.
Well, I'm not going to be in the office on New Year's Eve doing FinCEN filings. I will tell all my clients from Christmas Eve on, call Alan. All right, so now let's talk. We mentioned, and again, just to be perfectly clear, and I know everybody knows this, but let me just say it. Trusts don't file, reporting companies file. But trusts may be deemed beneficial owners either because of the 25% actual ownership, and there's all kinds of questions on that. We didn't really go through that because it's not unique to trusts, it's for any beneficial owner, or substantial control persons. But the defined term substantial control, and we've talked about it a bunch, it's very complex in the context of trusts having either ownership or control over a reporting company. And there are some FAQs and guidance on what this is. So again, it's not just the ownership, it's substantial control. Now, if you take a look at the FinCEN small business guide, and their materials are quite good in many respects, and they have schematics and other things that will help you and clients through it. But what is a person with substantial control? A manager or officer, director of an entity that will be a reporting company. All officers are beneficial owners by default, even those who own no equity. And that's why trusts can be implicated, even if they have a 1/10 of 1% interest in an entity, as Alan described earlier, as part of your anti-Powell-Moore planning. But this leaves open a lot of issues. Is the CFO of an entity a control person? What about a person with an employment agreement? It's going to depend on what's in that agreement. What about the head of a family office that manages entities? They're not a manager, but what powers or rights do they have? And now you have to take these concepts and graft them onto a trust, but it shows you how broad it is. It includes an individual with authority over appointing or removing a senior officer. So that's why I think if you have, say, an investment advisor in a trust that has any interest, if they have the ability to control who the officer, director, manager appointments are for the entity, I think they're clearly a person that holds substantial control, regardless of how little the trust actually owns. Then let's go on a little further. A person's considered to have substantial control if they have influence over important matters. Alan, can you tell me what an important matter is?
Oh my gosh.
What kind of coffee do you have in your office? Do you have a Keurig?
Yes.
That's pretty important to me.
Yeah, it's substantive matters, I guess, beyond the day-to-day business of the company. That's a tough one.
It's really vague. It's really broad. It's really worrisome. So when you have a trust investment advisor or investment trustee or a trust protector, how much authority or power might they have to have? Now, let me give you an example. Alan explained the idea of a special voting membership interest, and usually I would think you sell it because you have a better result of avoiding a chance of avoiding 2036 to that non-grantor trust. You use the example of grandchild's trust. I've used just general non-grantor trust. But let me give you another example of a concept that I've seen used to address the Powell-Moore issue. So one concept is to provide that if you have a trust member, you can't just let the trust have voting control, because often the clients are the investment advisor or investment trustee of their own trust. It's not a tax sensitive power, they can do it, but it becomes a tax sensitive power if they can control vote or liquidation. So one thing I've seen is in the operating agreement or a governing document for the entity, the reporting company, if there's a trust member, it is not the trust itself or the investment trustee or the trustee that has the authority to exercise a vote over liquidations and distributions, but that defaults to the trust protector, because those are usually people that are named, and you make sure they're named, are independent of the client, the settlor, in this context. So now the trust protector, under the terms of the operating agreement, is given the power to control or have influence or vote on liquidations or distributions in an effort to sidestep the Powell-Moore issue. I think that may make the trust protector, even if they weren't under the general terms of the trust, with the provision under the operating agreement, someone with substantial control. So it's not enough to just read the trust document in some cases to make a determination of who in the trust has substantial control. You also need to look at perhaps the governing documents of the entity that the trust has interest in. Alan, comments, thoughts?
I think you're correct. It's a scary world. You have to be overly thorough if you want to be perfectly safe.
In the context of trusts, an investment director, advisor, trustee may hold the power to control decisions as to the entity interests held in the trust. So that seemingly would taint them as having to report regardless of necessarily what's in the trust. So under 2036B, there's a risk that if the trust owns corporate stock and somebody can control the vote of corporate stock, the settlor, that now you have a 2036B estate inclusion issue. So in general, lots of the entities we see are LLCs and limited partnerships, and you may have the donor settlor who created it be named as an investment advisor. So they can control the investment decisions the trust makes, and that may be fine. But for corporate stock, there may, depending on how the trust is written, there's often a carve out that says, okay, we're going to name the settlor as the investment advisor. However, they cannot vote any stock in a corporation. And that may then default that if there is stock in a corporation that has to be voted and the settlor is excluded to avoid 2036B issues from voting it, well, then you may have somebody named to hold that voting power in the trust document in lieu of the settlor. Well, you got to pick that person up. And that's not the trustee, the investment advisor, the trust protector, which are the common culprits you think are going to be named. This is yet another person. And we've talked previously how power holders or an independent person like the attorney that has to approve the exercise of a general power may be implicated. And this is why I said earlier that, if FinCEN estimated 32 million filings of reporting companies, if you have two managers, co-managers of an LLC, and some of those interests of the LLC are owned by multiple different trusts, which is typical in the estate planning we do, right, Alan? You won't do any estate planning unless you have at least 6 trusts, right?
Right.
That way
Yeah.
you can bill more.
Yeah.
But the point is, you can have a non-reciprocal slat. You can have a carve-out non-grantor trust, a grandchildren trust to own a special voting membership interest. So even if you have 3 trusts owning one owner's interest in this LLC, a reporting company, and if you have 3 or 4 owners, they each may have their own trust structures. Within the trust structure, look at this list. And Alan, I think we should write up a list because it may be helpful to people and include the 2036, the power holders person, you know, the independent non-adverse party who has to approve the exercise of the power. You could easily have another half a dozen people or more for each trust. So this could be an incredible number of people that have to file. So you had raised the question earlier, and we had kind of talked about the agent under a power of attorney. And to me, it would make sense that if a client's incapacitated and the agent can control the voting of stock and the decisions on entity interests of the principal, that they should have to file. It seems that the FinCEN guidance indicates that a mere agent should not report, but if the principal is incapacitated, again, to me, it seems like they should, but that doesn't seem to be what FinCEN requires. Either of you want to comment about minor children?
They're very difficult to handle.
That's the joy of being a grandparent instead of a parent.
Well, there's an exception for minor children, but the question is, who is in charge of the minor child's stock or the minor child's holdings? And under the Custodian Act, is it the minor child when they're 21 or 25 that can take it back, or the parent who's still on there before the minor child takes it back?
What happens when the parents get divorced? Who's responsible for the minor child? Do they have to negotiate? I almost think they have to negotiate in the divorce agreement, the settlement agreement, which parent has the responsibility of doing the CTA filings for the child.
It's best not to have children because it just confuses things under the CTA Act.
That's a great answer, Alan. That's a great answer.
It's really, really small, but not every single state has the same age for like when you're not a minor anymore. Most places it is 18, but in some places it's 21, and then in others I think it's 19 actually.
I think there's 3 states that have 21, or not. 2 of them have 21 and 1 has 19. I don't remember who they are.
Yeah, so it's not exactly like a uniform rule across the country either for when you're considered not a minor anymore.
That's good because I couldn't handle anything that was too simple. And by the way, just thought of this. Under some of the state custodial acts, when a minor child attains the age of 14, I think they can petition the court to have the parent removed.
If they're self-supporting, or maybe
I don't remember the requirements, but I wonder if that now changes this. But lots of complications.
Mm-hmm.
What about professionals handling filings? So if you direct the creation of an entity, if you help with the filing, any thoughts or comments on that?
Well, it's the lawyer who directs the secretary and the secretary who does the filing. They're both in the mix. Now, what if 2 lawyers direct the secretary and the secretary does the filing? Then I guess
you only have 2. I think they cap it at 2.
Yeah,
Cap it at 2.
One firm I talked to didn't want to involve the administrative staff because they just felt it was unfair to impose this reporting burden on them where they'd have to disclose their confidential data. So a partner pushes, or an associate, but a lawyer pushes the button on any filings they do.
But if the secretary sets it up and the lawyer just pushes the button, then are you cheating the system?
I didn't ask.
And what about when the client files the articles on their own, but then you have to fix them and amend them to make it voting and non-voting? Then are we in the soup? I don't know. There's a lot of questions to ask LegalZoom, aren't there?
LegalZoom. Inheritors. Chriseanna.
Yeah, so as we mentioned earlier, whenever you just have an interest in something, you don't have to report yet. It's not until that interest is realized through the death of the actual owner. But you brought up a great point earlier about how long that could potentially take for the estate to close, and the fact that you have 30 days later to then update everything. But it depends on when you even get it, or if you even know that it's coming down the line. And as it says, if the testator died, does the beneficiary who's the inheritor count, or is it the executor in the interim that while we're waiting for everything to be finished? Like, who's actually in charge during that time period? And that time period could vary for a lot of different estates depending on what all is going on.
And what if you think it's in the estate, but then later on you find out it was really owned jointly with right of survivorship? And then 3 years have passed that you didn't know, and you should have known because you should have been a more responsible executor or executrix. So,
and now those fines are waiting for you to figure it out.
That's right.
I don't understand why they don't provide good faith exceptions to the penalties. I find this stuff on inheritors so vague as to be almost less helpful than had they said nothing. I find it very confusing. We've kind of covered that, so let's skip through that. So this is an interesting question. So certain assets, it'll depend on the nature of the asset, which person in the trust has authority. And the point of this comment is to show how absurdly complex this becomes. So one of the common situations that we see, if we create trusts in trust-friendly jurisdictions, Alaska, Nevada, South Dakota, Delaware, Connecticut, there's now, I think, 22 DAP jurisdictions now. So it's a growing number. It's a pretty large number. But let's say you create a trust in one of these better jurisdictions for a client that lives in New York or California. And the trust is going to buy a vacation home in a different state. Very common transaction. Lots of these trusts own vacation homes. You have to have the vacation home in an entity, typically an LLC, because you don't want a trust that's in South Dakota or Alaska or Nevada or Delaware owning real property in a different jurisdiction. It'll subject the trust, instead of to Alaska law, to home state law where that vacation home is. So you put the LLC as a wrapper on the vacation home, so it's an intangible asset and the trust is not subject to law in that jurisdiction. Let's call it New York. But there's a lot of difference in a trust. If it was a commercial piece of property and rented, the investment trustee or advisor may have responsibility for it. In some trusts, it may be the director general, the administrative general trustee that has responsibility for it. But if you have a vacation home that's going to be used by beneficiaries, some trusts, and I don't know if it's many trusts, but some trusts will default that or change that to make it the distribution trustee, who may be a different person, having responsibility, because it's a different kind of decision. It's not really an investment decision, it's a personal use asset. In some trusts where you have an institutional trustee, they may, in the trust document from inception, insist that if there's a personal use asset, that the decisions about that are in the hands of a individual, not the institution, which may be an named investment trustee. So depending on the application of what type of property is owned by the entity, the LLC in our example, by the trust, it may be a different person that has responsibility for it. So does that change who's responsible to report? And let's say one of these people didn't have to report, but now what was a rental property becomes a vacation home, personal use, or vice versa. Is that now a change and somebody new has to report? The permutations of this get just absurd.
Yep, absolutely.
Now, here's another question. So we draft these modern trusts with a half a dozen different fiduciary and non-fiduciary positions and power holders. How do we know what anybody's done? If you set up a trust 6 years ago, Alan, do you know if the trust protector, investment trustee, loan advisor have taken any actions since the date you set up the trust? How do you know? The only way you can know is to ask the people with these various powers to sign something like acknowledgement. No, I've never exercised any power since the date of the inception of the trust or the date of my appointment until today, or accept and then list what they've done. But that may affect who's named and what's going on. Has the trust protector acted to name a new person? And what we're doing now much more commonly. In the past, I would try to get people to give me names of people for all these positions. Who has the loan power? Who has investment power? Who's an insurance trustee? Now I'm defaulting to letting the trust protector name these people in the future, because if we name them today, they may all have to be BOIs under the CTA. So now we have to find out when we talk to clients and other advisors, accountants, if you're doing a trust income tax return, you want to find out, has anyone taken any action? Because that may all have CTA impact, because they may have appointed somebody where there was no appointment. We've talked about power of appointments. This is the same kind of language that we talked about earlier. We didn't even talk about SPATs. Alan, do you want to mention SPATs and what they may do?
Right. So I set up an irrevocable trust, and for tax reasons, I don't give myself, or any of the beneficiary a power to direct where the assets go, but I give my brother the power to direct where the assets go. So now my brother doesn't control the trust, but he can control where the trust assets go. So is he a control person if the trust asset consists of the control of a company? And the answer is yes.
I would think so. Almost every creative planning tool that we use, almost every modern trust position or technique or mechanism that we use seems to have CTA implications and add to the planning.
So there's 2 states in the United States that have a special kind of entity called a foundation. It's not a charitable organization. Foundations go back to Europe decades ago. It's an entity where the beneficiaries are not owners, but they're also not beneficiaries.
We've already clarified this. I probably should have this slide in the beginning. We've talked about it. Trusts are not reporting entities, but they may have to report as beneficial owners or reporting companies if they own 25% or more of an entity, or they can exercise substantial control. And there can be complexity and uncertainty on both of these, but especially on the substantial control. We've talked about that at some length. Oh, this is something that I've seen and I've done. So some trusts have multiple layers or committees of investment advisors. So for example, on real estate clients, sometimes the investment advisor is not a person, but a board that could consist of half a dozen people. We had many years ago a real estate developer, and the investment advisory board for the trust that made investment decisions about the real estate assets or entities, they're all in entities that the trust owned, included the principal, who was the settlor, a child of the principal, who was the heir apparent to the company, a CFO, and an outside accountant, and a 5th person. So a lot of these get very complicated. We also did a complex structure. It was actually based on religious planning, I won't go into, but the investment advisors were not only named entities, but those entities had a board that controlled them that consisted of, I think, 6 or 8 people. So you can get really complex layers of this. Alan, have you used entities as trust protectors or to house trust protectors to try to maybe distance yourself? So you create a trust in South Dakota and it's got entities that are operating, say, in New York, or I'm sorry, entities in various places, but the trust investment advisor that you want to have appointed lives in like a high-tax state like New York, and you're concerned that New York may try to tax the trust because of the um, residence of the trust investment advisor, so that you instead create a corporation or another entity that houses the advisors. South Dakota has a specific statute to facilitate that, but I think you can do it under other state laws as well. So you could have entities that now become reporting companies that house the people that are serving in these capacities that they themselves may have to report.
I've never seen that. It sounds like a good
Special
idea.
purpose entities.
Yeah, and that way you keep the real trust protector actors confidential.
Well,
But
you also try to insulate them from liability and make it harder for a high tax state to argue that because the trust investment advisors or trust protectors are resident in their state, that the trust is now taxed in that state because it's really not them named individually, it's an entity.
right.
I think we've covered all of this already. And I think we're getting pretty close to some final comments and discussions. Now, one of the questions that I think is also important, Alan, who do you represent in all this? Because typically we're hired, in most cases, typically by the trustee, but who are we representing? And how much of a concern is that? What do we want a separate engagement letter saying we're only representing the reporting company, the trust?
Well, it may be safest and best to get representation letters and to get that squared away, but I don't think that's the standard of practice. So everything's happening so fast, and some of these are just $500 and $600. Let us help you register. So
It's almost impractical. I mean, who are you going to get retained by? And I don't know that the reporting company is going to retain us when we're dealing with interpreting trust provisions on this.
right. But you can see that eventually somebody will be sued because some beneficiary says, well, I thought the law firm was representing me because they called me and they were very nice and they asked for my driver's license, so I thought they were my lawyer.
Yeah, I was gonna say, I'm obviously a lot more green than you two in this area. But just going based off like how they've taught us in school and everything, even though it would probably be a little awkward, it's probably best just for everyone to be on the same page, because you could run into someone being like, well, I thought that they were representing me. And like the courts are gonna look at that based on the client's interpretation of what's going on, not yours. And all it has to be is like slightly reasonable for them to think that. And then you're on the hook for something.
Like Alan said, you called the beneficiary to get some information because they're a beneficial owner, possibly under the very broad language of the CTA. And like Alan said, oh, they called me. They had to be my lawyer. I think that's a worrisome risk for a lot of what we do as practitioners, because the trust protector, the loan advisor, the person that can add beneficiaries, my belief is that they may all guess that we are their lawyer when we're not. We're only representing the trustee. And in some cases, we're not even representing the trustee, we're representing the settler who we did the plan for.
Yeah, so the letter we send them probably needs to say, thanks for providing us with this information. Please understand that we are using this information for the benefit of ABC LLC. We're not purporting to be your lawyers. Please don't give us any confidential information besides your address,
Social security number, driver's license.
Yeah.
Right. Please feel free to hire your own independent lawyers to review this matter. Yeah,
But it's even more crazy.
Lawyers are obnoxious because they're making me sign a conflict of interest letter. Yeah.
But we're trying to get the good faith, goodwill of the loan director, the power holder, whoever, to cooperate so we can get done what needs to be done, right? And keep everybody out of the penalty box with the CTA. And you're right, if it takes 15 minutes, as Chriseanna said, and she's right, to get a FinCEN identifier, how much can you charge, and how much time can you spend? I mean, the engagement letter, the retainer agreement could cost more time than with the conflicts than doing the filing. Doesn't make any sense.
Yeah.
One of the things that I think is also very important to talk about, what trust documents are we looking at? And when we haven't had a client in the office on a regular basis, and realistically, very, very, very few clients come back every year for an annual review. We may all tell them to do that, or at minimum to come back if anything changes. They don't. How do we know what trust document we're looking at? Have there been actions by the trust protector? Is the power holder exercised the power they have? Has there been a decanting or non-judicial modification where they went to some other lawyer because they were cheaper? We got to find out before we start interpreting the document what's in it. Here's the piece, Alan, that worries me a lot. So a client comes to me, they want the CTA filing done. Some filing service is going to charge $400 per filing. So they're already, worried about how much we're going to charge them. And they don't understand the filing service for $400 is not going to read an 80-page trust document and a 200-page operating agreement. But what do we do to protect ourselves? Are we opening up a Pandora's box that if we're looking at a trust document to review it to find out who has to file under the CTA, because you kind of have to, right? Are we now responsible if there's other issues in the trust document? If we say we're only reading the trust document for the CTA but for no other reasons, is that going to keep us out of hot water if there's a mistake unrelated to this in the trust document? And what do we do?
I don't know.
I want a smart answer, Alan. I'm not going to take I don't know, because I don't know. I'm worried about that.
Yeah. Well, you throw the broad net and report anything and everything and tell the clients we're relying upon you to confirm that nothing has happened with this trust instrument that would change this trust instrument. Make sure the CPA signs off on that.
And we're not reviewing the trust for anything other than CTA?
Yeah, that's another good point. You're right. Oh, that law firm, reviewed that trust and never told us that there was a GST exemption issue. They should have asked us whether there was a GST exemption allocation on a gift tax return. Sure wish they had figured that out. They're experts in trusts.
That's why we went to them.
Yeah.
That worries me. And like we were talking a few minutes ago, Chriseanna said it's 15 minutes to get a FinCEN identifier, $300-400 to a filing company. Some of them may charge less. How much time can we spend? Just the engagement letter alone could be more than this. I wonder if some law firms are referring their clients to the filing services who will do it for $300-400 and try not to get involved.
Yeah.
So we got to look at the trust documents. We got to see what else we should do. I think the better approach, which I don't think many clients will do, and we're not going to have time if this stuff is due by end of the year, is to let us review the trust if it hasn't been reviewed in many years. Let us review trust operation and all the documentation on the trust, but that's just not going to really happen. And it's the same issue with the entities. So Alan, those green boxy things, those corporate kits that clients have that have like the required 2-inch layer of dust on them because they haven't opened them in 30 years. I mean, how often do you see somebody that has an S Corp from 20, 30 years ago and nobody that's named in the bylaws is even alive anymore?
Yeah.
So
yeah.
The right way to do all this, which is not happening by year end, is the entity documents need to be updated. And you may have to do that because you can't file for these other people. And take a look at the FAQs because, and Alan, we did another program on this, which we're not going to get into now because we're pretty much out of time, on what happens with dissolved entities, another whole mess where FinCEN has taken what seems to be the more complicated, most complicated of approaches. So any final concluding comments, Chriseanna, then Alan?
No, I think like you pretty much covered it. I would just say maybe don't wait until the last minute to do this because
We're almost there.
yeah, the site's more than likely not going to be at its strongest on New Year's Eve. I think it's better to get it done now.
Well, Howard Zaritsky says many times, don't let your client's problem become your problem. So, when the oxygen masks come down, put yours on first. Explain to the client that they can go to the LegalZoom website and do this on their own, and that we'll be glad to look at it when we get time to correct anything. If they went and they registered it wrong, doing the best job they could, and we look at it and get it corrected within a reasonable period of time, that would be evidence of good faith. But lawyers make the mistake so often of taking on more work than we can do. And this, unlike my favorite author, Douglas Adams, says, I love deadlines, especially the whooshing sound they make when they pass over you. This is a deadline that I don't want to have on my desk, December 31st. You have to tell the clients, I may help you. I may not be able to get this done. LegalZoom has, a website where you can get it. You'll probably get it wrong, but do your best. I'll handle the rest. And then the form letters need to say, we did this for you. We were in a rush. We did not review the trust agreement. We may have missed something. Here's a 90-minute webinar that we did with a friend. Why don't you watch this webinar and check with your other legal counsel and make sure that all this was covered. Otherwise, we'll be glad to do it. Here's our retainer letter. If you don't want us to do it, no problem. Dear shareholder, we helped you. We got you your FinCEN number. Please advise that we did not purport to represent you individually other than to help you get your FinCEN number. You can get independent legal counsel, and maybe all that stuff is, worth doing. In the long run, if you made a reasonable effort to know these rules and you made a reasonable effort to get this done right, you did your best, your client's not a gangster or a tax evader, you're probably okay. Life goes on, but it's best to be careful.
I think we've said it many times, but in the end, especially with trusts, it's almost like just have somebody review the trust document and write down every position and every name in the trust document. And unless it's obvious that this person or position doesn't have enough authority to be a substantial control person, and you know that the trust has interest or control over an entity, just have everyone get a FinCEN identifier and give it to the reporting company and let them file. I mean, that seems to be the default approach. It doesn't make sense to spend hours of time trying to figure out if you can avoid filing if you can just file.
Right. And it's always the best approach to review an old trust and see if you want to update the trust. So the good news and the silver lining is that thousands or 10,000s of trusts eventually will be reviewed and improved and updated because of the CTA. And, and it's good, it's good to have a reason to reach out to your biggest, best clients or your favorite clients to say, hey, because of this CTA, I really think we should sit down and see what this 1987 trust says and whether we should update it, and maybe we can save you some taxes and some family litigation in the long run. So maybe the glass is half full here.
Thank you for joining us. Thank you, Chriseanna. Thank you, Alan. CTA is complicated, doesn't make a lot of sense. I know a lot of people are hoping that some court will say it's gone, but that hasn't happened. And I think wishing and hoping for that is not the way to go. The deadline is really close. I think what Alan said is practical. Help clients deal with what they can as efficiently as they can before the end of the year. And I think given all the other things that we all are going to be burdened with and are burdened with for year end already, that the review of that 1987 trust in Alan's example, that's going to happen sometime next year. Just tell clients so they don't have a different understanding than we do as to what we are or are not doing for them. So thank you for joining us. I hope this was helpful and practical, and we'll probably do some more on the CTA because it doesn't seem like it's going away. Take care, everybody, and good luck.
Thanks, Marty. Have a great day.
Bye.